Miss Day, we are in a position to announce our decision on both appeals as follows. The appeal by the defendants against the judge's decision to allow re-amendment of the claimant's statements of case will be dismissed. The appeal by the claimants against the two declarations made by Mrs. Justice May, namely, first, that the claims are to be progressed on the basis that they're global claims, i.e. all or nothing claims, and second, that the claimant's pleaded case precludes case management of this litigation being organised by reference to the selection of lead claimants. That appeal will be allowed and both those declarations will be set aside. We will issue a reasoned judgment in the usual way, and will do so this term. We hope well before the end of this term, but we can't give any binding undertakings. Our present view is that a case management conference should be held in January 2025, if that is possible, and that we shouldn't make any order as to what should happen at that case management conference. But as Mr. Willen made submissions about whether we might give some broad indications as to what the judge should do at the case management conference, Miss Day, if you wish briefly to do the same, of course we'll hear you. As we indicated to Mr. Willen, whether we will give any such indication in the judgment remains to be seen. If you'd like 5 minutes to think about it, by all means, have 5 minutes to think about it. And I ought to mention now, lest I forget later, what is known to all counsel, but I still have to say it, two things about handed down judgments. First of all, they are confidential to the lawyers and anybody else who needs to know to give instructions until the final handed down text is handed down. And secondly, that the hand down, that the draft is sent out for correction of obvious factual errors, not for re-argument of the case. There we are. I've got that off my chest now. Would you like to make submissions straight away, or would you like to discuss for no more than 5 minutes with those around you whether you want to make submissions, or you may say you don't want to?
I would like to make submissions if
Right.
the court could bear with me for reasons that I will explain, because there is a concern on this side of the court. We're obviously very grateful that the appeals have been dismissed and our appeal allowed, but we are very concerned about going back into another round of years and years of further disclosure, the same arguments again. And therefore, I would briefly just like to explain what we see as the real problem arising from the global claims and the spills and the events terminology, so that the court, we would ask to make clear that that's not to be applied going forward. Secondly, I would like to address you in relation to considering giving a direction in relation to disclosure, because we are currently in a position, and I can explain why, but we're currently in a position where we were proceeding to have standard disclosure. We then had the global claims, and I'm concerned that unless that is debunked and cleansed out of this litigation, we'll go around again. Third, if I could address you on the on giving a direction that the case should be dealt with by way of lead claims. And then finally, there's the question of the managing judge and whether this is a case that should be remitted to Mrs. Justice May, or whether you would consider making a direction that would be remitted to a new managing judge.
Right, we'll take those one by one.
Yes. So if I could ask you to take out the permission to appeal. This is Mrs. Justice May's refusal of permission to appeal in this case. It's in Core Bundle 1, tab 16. And if we see where she's set out the result of the hearing trial, it's tab 16, page 270. You will see that she set out there the result of the hearing was determination that the Bille claims are to be case managed as global claims with orders for disclosure and scope of future trials made on that basis. And then if you could turn over the page, please. Page 271. She sets out there that grounds 1 and 2 are unarguable because the concept only applies in building cases. Fine, I'm sure the court will deal with that. She then says this: even if the concept material contribution applies, the events making a material contribution have not been sufficiently identified here.
Where are you?
It's in the box at the top of 271.
Okay.
Yeah. And all of the submissions that Mr. Willen made to you before lunch were made on the basis that we must prove specific events. And worse than that, it's not just that we prove events, it's that we prove specific spills, which are defined by reference to the spills that Shell has records of that are recorded on the public website. And as my Lord Justice Mayall said, and as is clear from what we've set out in our skeleton, wherever it's possible, we will seek to attribute the damage to a specific leak. But it is also our case, as you know from the systemic breaches, that there may have been a complete failure to maintain and repair pipelines, such as there were lots of very tiny leaks, and we may not be able to pinpoint each item of damage which we complain about to a specific leak. And that's in the evidence before you. So it's Supplementary Bundle 2, tab 28, page 594.
Does it come to this, that the defendants have argued that the case should proceed no further until and unless each claimant pleads causation by reference to specific spills?
Yes.
And you say that's wrong,
Correct.
but that's an issue of principle which we need to deal with in the judgment.
Correct.
And not simply leave the issue of principle to a case management conference, although the details might have to be reserved to the judge.
That's absolutely correct. And this may be my fault, but I wanted to just walk you through. Walter Lilly uses the word event in the context of contractual allocation of risk. And I was going to take you, and again, if you might indulge me, I think it would be useful to take you through that. I'm very, very keen in the judgment that we get rid of that term event, because what it leads to is a reversal of the position that applies in tort, which is that we are allowed to prove cause or materially contributes to through an inferential case. We don't have to pinpoint a specific event. The reason you have to pinpoint a specific event in a global claim in a construction sense is because you only have a claim if there's an event in the contract that is the defendant's responsibility. So what the court is doing in that context is enforcing the parties pre-agreed in a contract, obviously sacrosanct, the court will uphold it. The court is enforcing that allocation of risk, and the court will do that even if it's unfair. Whereas, of course, in tort, that's not the rule that applies. So I can talk you through, but that pervades the defendant's submissions, and it is incredibly important that the judgment deals with that. Otherwise, we will be back arguing before the judge, having the sort of arguments we were today, whereby the defendants stand up and say, if you can't identify every event, then you fail. And what we say, as I say in our skeleton, is that we will seek to identify specific events. But if you look at these paragraphs of Mr. Renshaw's witness statement at page 594, paragraphs 107 and 108, he explains how poor maintenance can lead to pinhole leaks that over long periods of time will leak oil. And 108, he also talks about undetected leaks, the evidence of Mr. Igwe. Even though you can't actually see the spills, there may still be leakage coming out of the pipes.
Yes. What are you asking us to do? Looking at your skeleton in the global claims appeal, if we go to page 198, starting from the end, what you ask is that for the reasons set out above, the Court of Appeal should allow the claimant's appeal against the order, should declare the claimant's claims are not global claims, and direct that the claims be progressed through the selection and trial of lead claims.
Yes.
I think you can take it from what we've said so far that is our view, but you're asking us to do what? Do you want? Are you saying that we should make an order, or that we should indicate how this is to be dealt with?
Yes, well, it's really through the second declaration. When you declare they're not global claims,
Yeah.
within your reasoning, it's setting out and debunking what's crept in. And it's very clearly set out in the refusal of permission to appeal, where she says, even if the concept of material contribution applies, the event or events making a material contribution have not been sufficiently identified. I mean, it may be, if you could bear with me, that I could just talk you through the submissions I was going to make on this, because I completely agree that it is for another day, whether or not, or precisely what test applies in tort. But the difficulty is, in terms of the global claims test that's being applied, it's still being applied by the claimants, but by the defendants, even when Mr. Willen stands up and says, well, I assume that I've lost on 1 and 2. But even if I've lost, you still have to plead the events. You can't plead the events, and therefore we go down all these routes.
Yeah.
And again, I can look at the judgment, because again, that shows within the judgment where this is creeping in.
Just give us the reference.
Yeah, so it was the passage that Mr. Willen took you to, and he said, I'm assuming the appeal's been allowed, but this is critical. Look at the reasoning in her judgment. So it's paragraph 43 he took you to, which is page 46. So that was an indication that it was felt that paragraph could still be relied on, even if our appeal succeeded. Now, can we start at 42? Because he started at 43. At 42, she says there's no distinction between construction claims and environmental.
No, we've covered this many times. I understand that your argument has been that it is unreasonable and inappropriate for the claimants to be required, particularly all of them, to identify specific spills.
Yes.
But what are you asking us to do? Are you asking us to tackle this topic in the judgment, or are you asking us to make an order as to what the judge at the case management conference should do?
Well, what I want to ensure doesn't happen is that when we go back before the judge, that Mr. Willen or Lord Goldsmith goes, as happened today, goes to paragraph 43,
Yes.
turns it up and says, yes, well, we've lost on global claims, but the judge still says, either way, as I see it, a case needs to be made identifying the particular events relied on.
You're worried about events.
I am worried about that.
And hence your wish to take us, or at least refer us, to Walter Lilly, where I think we've got the passage in mind.
Yes.
And the distinction you make is between there, where it's contractual allocation of risk, and here, where, to a greater or lesser extent, it's a case in tort.
Yes, and it's quite a difficult position. You've obviously allowed the appeal. We're incredibly grateful. It was simply in light of some of the submissions made, I wanted to give the court a bit of further assistance in terms of how far, I say, you debunk the logic of global claims. Otherwise, it will continue to be applied against us, because on the amendment application, it was also applied against us. And it's completely wrong to use the word event, because event within Walter Lilly has a very specific meaning. And within the tort world, we are permitted both to prove it by direct causation, but also to obtain the evidence and then to plead a case based on inference. but we can only do both once we have standard disclosure. And that leads me into asking you to consider directing that the next step should be standard disclosure. My clients are now in the 10th year of this litigation. 3 years ago, the Supreme Court said we should have disclosure. And the effect of Mrs. Justice O'Farrell mentioning the word global claims is we've been stuck in this vortex for the last 3 years, unable to move forward. And we are incredibly concerned that we can move this forward. And it would be incredibly helpful if there can in some way, and I appreciate this is an unusual request, but in some way, either by order or indication, that the next thing that must happen is standard disclosure. The parties were in the process of agreeing standard disclosure when this global claims nightmare started. And we've gone backwards since then. So we don't ask you to go into the specifics of it. Obviously, exactly how it works under the rules would be a matter for the judge. But again, I can show you the bit of Mr. Renshaw's statement isn't in the bundle, actually. I can show you quite how far. You've got part of his statement, you don't have this part. It's incredibly helpful. It shows how far the parties were down the road of following the standard disclosure rules in the KB when global claims arose.
Was it standard disclosure as a whole or standard disclosure on particular issues?
No, it was standard disclosure as a whole. Right. It was under the CPR, and it was the mention of global claims that led to the defendants saying, aha, now we have a chance to say you should be struck out or you should be prevented from getting any disclosure from us until you have pleaded out every single event. And by event, they narrow it down further to say spills as we define spills.
Well, if the event means or includes the process of a large number of tiny leaks that you say you can't pinpoint, won't the effects of those leaks be apparent from, for example, the satellite imagery, which will show pollution around certain parts of the pipeline? And it will then be your case that, for whatever reason, those leaks were the result of corrosion, poor maintenance, etc. But you could identify where there was leakage from the pipeline and perhaps the approximate time at which it happened, even if you can't pinpoint, as it were, a specific event, in inverted commas, because such an event didn't happen. That wasn't how it works.
No, we can establish liability without ever having to prove that a specific event occurred on a specific date, so date X at Y location. So, for example, in Bodo, that actually was a case where there was a complete lack of maintenance that led to a lot of leaks from the pipe. And I can hear next to me complain. Let's make this hypothetical. Say we get the maintenance records, there's a total lack of maintenance. We would be allowed to say the court can infer, even though we can't now prove at location X on date Y there was a leak, that this pipe was seeping oil out. We would be allowed. And the word event comes entirely from this global claims case law. So we are extremely keen that that's made clear in the judgment. Otherwise, you're not going to cleanse this litigation of what's happened through global claims. And you can see that through the pleading. There are also sections of the defence that will need to come out because they refer to this same point, which again I was going to take you to. But we are concerned about that, and we are very concerned. And in being blunt, and indeed Mr. Woolen said it today, what this is really about is that the defendants do not want to give us their fault-based disclosure. And he said in terms, if we are ordered to do that, we'll settle.
I don't think he did. He was.
Dream on.
I thought you were going to say
The exact reverse, that he hypothesised that
he did say
that
everyone...
this might lead some litigants to settle, but experience of the last 8 years shows that it might not happen in this case. Anyway.
Everyone laughed. If we look at the transcript, he did say to you that could force a settlement. He didn't say it won't force a settlement for us. The submission made was that it could force a settlement because it would be so expensive.
Right.
There is, as we looked at when we saw the judge refusing to order the maintenance records, for example, there is very good reason for disclosure to take place. And we are very, very keen that this court debunks the word event out of the litigation and debunks the spill approach. We are also very concerned about being in a position where we have further rounds and further years of debate about specific disclosure.
Specific disclosure, if the case is to move on at all, would be those classes, the request for specific disclosure would be those classes of documents which you say are relevant, first of all, to the question of whether or not spills can be identified. And secondly, as I understand your present submission, documents that would support an inference that there may have been or were more spills than can now be identified. Or,
yes, and it's
attributed.
Yeah, it's not just spills. It's either the conditions of the pipe of pour, so the leakage.
But I'm using it in a
generic way.
I was about to say global, but I think I better not. But that speaking for myself, I don't necessarily need to see it now, but I think speaking for myself, I would be interested to see what you've referred to as illustrating how far down the line standard disclosure things had got.
Yes.
If there are orders and that were subsequently reversed and things like that.
Yeah. If I could just show you briefly your hand itself. Thank you.
Please.
So these are some additional documents from a statement that's in the bundle. The statement is in the bundle at supplementary bundle 2, tab 30, and it starts at 626. This
16.
is 626.
Thank you.
This is from the 8th statement of Matthew Renshaw. So this was produced after the November 2023 judgment. And the passages that I would just direct your attention to are 21 and 22. And 22, you will see that the directions envisage that by the point a judgment was given in a Nigerian law issues trial, the parties will exchange standard disclosure and will have at least made considerable progress towards reviewing it.
Where are you? 21.
21 and 22, but 22 is where we see. So this was the way of progressing things as quickly as possible, but in particular 22. So you would have specific disclosure to get things going, but then with standard disclosure in tandem with that, effectively, and being progressed. And then if you go forward to 24, paragraph 24, you will see his 7th witness statement again had a history of the correspondence. But we don't burden you with that. But what there is within this is a summary of the extent of agreement between the parties regarding disclosure to date. The draft directions on disclosure have been discussed between the parties, and so far have been the claimant's proposals in the context of a lead claim. There have been 2 significant disclosure meetings between the party solicitors here, but it was all brought to a halt by the global claims. So if you look at A, you will see the parties agree that standard disclosure should be directed, and there's a footnote there that refers to correspondence. Until
Sorry, my learned friend, I haven't seen this before, but perhaps note the beginning of that, which says we're optimistic that the parties will remain agreed on the following points. I'm very keen to see where it said that my clients agreed to what she's reading.
it says we are optimistic that the parties will remain agreed on the following points. If I could just make my submissions without being interrupted. The parties agree that standard disclosure should be directed. There's a footnote there to correspondence. And if you read the footnote, there are specific letters which we can give the court, if that would be of assistance. And you will see that the defendants had actually completed disclosure reports. And then it says, we note, however, the defendants have referenced issued-based disclosure in the preliminary issues trial.
Well,
Then,
again, what I see why you're referring us to this, but what are you asking that we should do?
I'm asking that it should be made clear that this process should be continued. This is the process that was halted, the process of agreeing and providing standard disclosure as soon as possible when the global claims issues came up. Again, I won't read through it, the court can read it itself. It's very clear that this was what was in process and has been halted. And we are very, very keen that that process should be started again. So we are keen that a clear steer should be given on that, as well as on the fact that this has to be managed by lead claims. Obviously, how it's managed by lead claims would have to be determined by the managing judge.
Yes. Well, I think you can take it, again, to say, indeed, I think it was conceded that this case has to be managed by lead claims. It cannot possibly be a 2,000 claimant mega trial.
Yes.
How the lead claims should be selected and so forth, we may not want to say much about. But anyway, we've heard submissions about it. But,
yes. Yes, that's a matter for the court. I don't press that. What is extremely important, if we aren't going to end up with months, if not years, of delay and going through more arguments about whether it's specific disclosure or standard disclosure, is that we now proceed to have disclosure of the fault-based documents, the maintenance records, all of those records which go to our pleaded allegations, and that we don't end up in a situation of somebody still referring to this judgment and saying, as was said to you today, paragraph 43, well, we can rely on this to say you have to prove events, you have to prove spills as we define them.
All right, we've got your submissions on that.
If I could deal briefly with the point as to which judge hears this going forward. If I could just hand up an authority.
I think this is fairly familiar territory. Is the position any different in case where the President of the King's Bench Division has nominated an individual as a managing judge?
We're conscious of that. There's one paragraph within this that I'd ask you to look at. It's 46.4 at 4360.
Sorry, which paragraph?
It's 46.4 and it's got the heading totally flawed decision. And it starts, it would not ordinarily be appropriate to send the matter back to a tribunal where, in the conclusion of an appellate tribunal, the first hearing was wholly flawed or there has been a complete mishandling of it. Then these words are important. This, of course, may come about without any personal blame on the part of the tribunal. There could be complexities which had not been appreciated, authorities which have been overlooked, or the adoption erroneously of an incorrect approach. The appellate tribunal must have confidence that with guidance the tribunal can get it right second time.
But it's the last sentence, isn't it?
Correct.
And your submission is that if we don't have confidence that the same judge can get it right second time, then we should direct it be listed, or we should request the President of the King's Bench Division to consider appointing a different judge.
Absolutely correct.
This is, in fact, a quotation by Lord Justice Voss, as he then was,
It is, yes.
from Sinclair, Roach and Temperley and
Yes.
Hurd and Fellows, which was my very last case as a barrister.
We did
So
notice that.
I am familiar with the
You
case.
would be familiar with it, yes.
Yes.
Yes, we had spotted that.
All right, thank you.
So we ask you to consider that. Obviously, one of the sensitive issues is we have the preliminary issues trial in February. We do say it would make sense for the same judge who's managing it to deal with that. But we leave that with you. We appreciate this is an unusual situation, but I do ask you to reflect on the transcripts, the judgments that I've taken you to, and to see if the original tribunal would be able to deal with it in this way if it was remitted back to her. Again, we say that without seeking to ascertain any blame. The other point, and certainly I should say, and of course I don't need to do this now, some of the submissions that were made to her were with respect. they're very difficult because they do that classic thing of taking one sentence out of a judgment and applying it in a completely different context. And I simply reiterate, and I would ask you to read Walter Lilly and to look at the way in which event is defined in the contract in that case, because it has a very specific meaning. And that case is to do with when a claimant who has a contract under which it's been agreed between the parties that there's an allocation of risk between the parties, when they can claim loss that is attributable to certain events as defined. And that doesn't translate into tort, because there the court is very, very keen to hold the parties to their bargain. So we say that the only other case we found, which we hope might be of assistance, was, I think, one that Lord Justice Stuart-Smith had in mind in relation to pleadings, and actually it relates to the cartels cases that Mr. Willen mentioned. If we could just hand that up. And again, it's just a couple of passages from this, paragraph 30 and 31. But you will see at paragraph 30, this is referring to competition law cases, participants in a cartel. And it says this: the courts will tend to allow a more generous ambit for pleadings where what is being alleged is necessarily a matter which is largely within the exclusive knowledge of the defendants than it might in other cases. I agree that a more generous approach to pleadings is appropriate, as has been recognised in a number of cases. And then, quoting from Nokia, if you turn to the quotation, the second paragraph quoted, 4 lines from the bottom, discussion of a balance being struck by allowing a measure of generosity in favour of a claimant. And then 31, this generous approach to pleadings in cartel claims has been endorsed by the Court of Appeal, and then set out. Now, this is much more analogous to this case. Construction cases, Walter Lilly, those cases, and you will see it again in the judgments if you look at them, those cases are about a claimant's own records. So to plead out loss, the claimants in those cases do not need any disclosure. In fact, the disclosure of the defendant would be completely irrelevant to their claim, because their claim is about their own loss. And they keep their own records. More than that, in those construction claims, it's not just about making claims in court, it's that under those construction contracts, you make claims to the contract administrator during the course of the project. Often you have conditions precedent, which mean claims have to be brought as soon as reasonably practicable, so they're made or should be made as you go along in the project. But the important point, the most important point, is in those cases, the claimant has sole control of the documents that exist to prove its claims. Our case is much more analogous to cartel cases, where it's the other party that has all the documents. We want to plead this case out, but we want to plead it out in the individual particulars of claim. We've done our generic pleadings. There was an application to strike out which was dismissed. Those pleadings are adequate. And that's really why I hope you can either give an order or provide a very strong steer that the next thing that happens is disclosure. And then the managing judge can decide how lead cases are selected, etc. That's obviously a matter for the managing judge. But we are at the point where we've spent 3 years on generic pleadings. They've been held, they've been attacked, they've been held to be sufficient. We must now move on to having disclosure and then having the individual particulars of claim. And within those, we set out our case in full, as we've undertaken we will do in that paragraph of our skeleton. And we will absolutely do that. But we absolutely need that disclosure. And there's just one other document you haven't seen, because you had a lot of submissions to you about how unfair it is to the defendants of ordering them to give disclosure. If you can look in the unagreed bundle, please, the last tab. When Mr. Boyne put in his last witness statement, he attached this document to it. It's something that comes from the June, something prepared for the June 2024 CMC. It's a witness statement of Hugh Simon Tillotson. And if you go to page 102, paragraph 4, you will see that this was put in by the defendants because the court at that point was considering what documents will be needed for the 3Cs trial. And at this point, it becomes clear that the defendants embarked on something between 2013 and 2016 called Project Nautilus. And it's said to be of particular relevance to these proceedings. And if we turn over to page 103, paragraph 7, Mr. Tillotson, who's a partner in ERM, was retained by the second defendant to conduct what he calls an environmental baseline assessment. And that was prepared because there was to be divestment of the second defendant's interests in these licenses. And if you look at 9, he says the purpose of Project Nautilus was to have an independent third party to compile data from numerous sources, which would provide the defendant with detailed evidence on the environmental conditions at the point of the study. Our instructions were to be factual, robust, transparent, and defensible.
Are the Nautilus assets are the assets, the physical assets of the refining operation or the oil operation?
Correct. So if you look at 7, they're actually wider than that. So you've heard protest how onerous it would be to provide disclosure. The Nautilus assets are OMLs, so the licenses 18, 24, 25, 29, and the NCTL, which you've seen reference to. And then you see last sentence of that paragraph, the Bille area falls within licenses 18, 24, and the NCTL. So this actually covered more, but obviously it would be applicable to here. And if we go back to 9, defensible, and the next sentence is very important. By defensible, I mean our assessment needed to stand up to scrutiny in the event of future claims and be capable of use in any potential dispute. So what happened from 2013 onwards is that the defendants were preparing for any future claims. And if you look at
They were
11,
preparing for claims in the future as a result of pollution by their successors, surely.
well, that's not clear.
Isn't it? It's pretty clear to me.
Well, if you look down at 11C, you will see there was provide a clear and robust and clear deliverable that was of value to Shell and its JV partners in the event of future environmental claims.
That's what a baseline is.
Yes,
This is how it is when we're handing it over to our successors. So we're not responsible for anything that makes it worse. That's what they're trying to show.
well, not quite. If you read on, what they did was they focused on taking photos of illegal refineries. So we can skip forward. Paragraph 40, if you look at 113.
And they've exhibited the report.
They have.
I gather,
They've been.
although maybe not all annexures. I don't know. But, so you've got photos of all the illegal refineries, have you?
You have, but and again, this is
So you know where they are?
resolve. Well, no. What? Yeah. So this is creating a record. Let me take this in the terms of the points that we take from this. One, a record has been collected. So the suggestion that it's unfair to the defendants isn't correct because this was all done at that point in time. But two, it cannot be right that all they have to hand over to us are these documents, which is basically what we've been getting. They're the pre-packaged documents that were prepared to be handed over to defend their position in the event of claims. We are entitled to see the asset maintenance records. This is what will come through standard disclosure, the fault-based documents, the documents from the parent company. All of those documents in my submission now need to come. And that is why, when it's said it's very unfair and we don't know about this huge, vast area, that they have already been putting this work together. They've already done that work to put themselves in a position where they could defend claims. So we simply don't follow the suggestion that it would be unfair to them to make them provide disclosure. And as I say, they were preparing to give disclosure until the global claims issue raised its head.
And that would be pursuant to the general obligation under the rules. It doesn't have to come from an order. It's just that at a certain point in litigation, the parties are to provide standard disclosure unless some contrary order has been made.
Yes, and the documents I handed up earlier show the parties were in that process. And we would like to go back to that process rather than have to spend, whenever we may get a CMC, and then have to start arguing again about whether we should get standard disclosure, specific disclosure. The reason that Mrs. Justice May refused standard disclosure was because everything was seen through the global claims prism.
And standard disclosure is not of every document that's ever come into existence.
No.
It's of documents which weaken your case or strengthen the other side's case or arguably do so.
And there are rules of court which provide for that. And if there are specific things that are said to be too onerous, that argument can be had before the managing judge.
Yes.
But the linchpin of your argument that you're putting to us now is your assertion, right or wrong, that it is acceptable in a claim in tort to arrive at a final position where you may be able to identify specific occurrences which you say cause damage,
Correct.
which individual claimants may rely upon. But there is another route to liability, which involves inference.
Correct.
And as I understand the submission you're making this afternoon, but please correct me if I'm wrong, your submission is that in a case of this kind, once your generic pleadings have been held to be sufficient,
Yes.
as we've indicated they will be, the next step is standard disclosure, and then you would proceed to lead cases on the basis of whatever expert evidence is gathered together and so on and so forth.
Correct. Correct.
That's it, isn't it?
It is absolutely it. And in that sense, we say lots of things will be in the managing judge's discretion. But one thing that's clear now is the next step is standard disclosure. Then we move on to selection of lead claimants and individual particulars of claim. But that's the key to unlocking this litigation and allowing it to progress forward. And that is what we've spent the last 2 years battling. And we are very, very concerned that if that steer isn't given or an order isn't made that makes it clear, we will spend another couple of years battling.
Well, I understand the point about events and so on.
Yeah.
That's relatively straightforward.
Yes, but it goes further than that, because you've seen every angle is going to be taken on this. Every angle. There is no reason why we are not entitled to standard disclosure now. We've pleaded out our claim. We've given voluntary further particulars. We've spent years going to speak to every single one of these claimants. We can't go any further forward. If we could just have this, we could actually get our experts to work. We could start progressing this claim. And therefore, it is of fundamental importance that that process of disclosure starts as soon as possible.
Thank you.
Sorry, I'm just checking. I don't think there's anything else, unless there's anything else that I can assist you with.
Thank you very much. Mr. Williams, I think that was all by way of reply to you.
It was.
It saved the point about the managing judge
Yes.
and the citation of Mr. Justice Flo's case about cartel claims.
Yes. Which I did in fact mention, albeit perhaps
So you did.
elliptically.
Yeah.
Just before I turn to that, may I just confirm with your lordships that you're not planning to make the order dismissing and allowing the appeals today? Just because if you are, I need to apply protectively for permission to appeal, because I don't think I can do that after you've made the order.
That's an indication, not an order today.
It's an indication, not an order today.
Thank you. And that's not to indicate we will apply for permission. I just don't want to, not having taken instructions, give up, lose the ability.
I don't think it's necessary, certainly on the main points of dismissing Appeal 1 and allowing Appeal 2 and setting aside the declaration. We certainly don't need to make any order in advance of handing down judgment, and any indication, for example, that we think a CMC should be held in January 2025, that doesn't require an order either.
No.
You know that's our view.
Yes.
Right.
But it does encourage them to take steps now to get an appointment. I was going to, I know what to say if they disagree, but I was going to suggest that it does encourage you to take steps now to get an appointment in January,
Yes.
rather than waiting for the judgment to do so.
Yes, and I can't imagine that listing are going to say, in the absence of an order, they won't act on an indication from the Court of Appeal. So I'm sure we can do that. My Lord, the second just procedural point is my learned friends made certain submissions on where we reached on standard disclosure. Now, if your lordships are going to take those into account, which are new points, the document wasn't even in the bundle, we don't agree with that characterisation. And you'll have seen there was reference in a footnote to discussions of issue-based disclosure. We certainly, for instance, were suggesting issue-based disclosure about spills. So if your lordships do plan to take that into consideration, we would ask to be given an opportunity to perhaps put in a couple of pages just to set out our position on where we had reached. But I don't know whether your lordships are.
I mean, I'd be content if he wants to put in 2 pages, that's fine.
All right.
The replacement of Mrs. Justice May, let me put it this way. We are very concerned about what is or may appear to be judge shopping. And we would certainly, it's a matter for this court, I don't think it is a matter for us, we would certainly say that subject to seeing your lordship's judgment, it is extraordinarily unlikely that you will reach the conclusion that the learned judge, adopting something that another experienced judge, Mrs. Justice O'Farrell, had said, had gone so completely wrong that she cannot be trusted to manage proceedings in light of this court's indications. I don't think I can say anything more than that.
No.
May I just finally conclude by saying, just so there's, in case there's any confusion about this, my learned friend took you to the Project Nautilus references. Obviously, the Project Nautilus environmental baseline assessment was a category of specific disclosure. And so 15,000 documents that had been collated as part of Project Nautilus have been disclosed. So I'm not quite sure what my learned friend says, well, it's all been collected, so it's very easy to be produced. That in fact has happened. It doesn't really help on standard disclosure. Haven't collected emails and that sort of thing. So, my lords, just to make clear that to the extent it was being suggested we hadn't disclosed documents within the Project Nautilus environmental baseline assessment, the environmental baseline assessment was a standard a specific disclosure category. I don't think, obviously, I don't agree with a lot of my learned friends said, but as you say, that was legitimately reply, and it's not for me to have another go on that.
It was. If you do want to put in 2 pages of submissions about why there should be only issue-based disclosure rather than standard-based disclosure, how long do you want for that?
If you would, can I pitch? If you would give us to next Friday, I'd be grateful.
You're not going to get the draft before next Friday.
I rather assumed that would not be on the critical path. If
we give you till next Friday, and Miss Day and her team, if they want to respond again in 2 pages by the following Friday, and heaven help anybody who wants to prolong the debate in writing after that. Any other business for today?
I'm seeing shaking of heads.
Just to thank you very much, and also Mr. Willen, I know, has also had vomiting children. So just to make clear that we're trying to decide who's infecting whom in this courtroom, but I hope everyone else remains well.
I'm rather troubled because I've been sitting between the two.
Oh no.
Yes. Well,
But thank you for dealing with this so efficiently. I'm sure I say this from everybody's point of view, with humour, particularly given the number of bundles. I think many courts would have been much more.
it hasn't been so bad at all. Well, we are, as you've seen, a mixture of old-timers who prefer hard copies and my more modern colleagues who like everything on the screen.
that we've managed. We're very grateful to all of you for your submissions, not only those of you who made oral submissions, but junior counsel, backup teams. Great mass of material has been beautifully prepared. Thank you all very much indeed.